Hi, good evening. I'm Alex Valdez, and I'm an attorney with Winstead PC. I'm here on behalf of the Texas Association of Builders to oppose the bill. I'm a board-certified Property Owners Association attorney. It's the first year of certification. There are about 30 of us in the state of Texas, but I've been practicing law for 17 years, and I represent a number of property owners associations, I believe over 100 property owners associations, and the majority of my owners associations that I represent are owner-controlled POAs, both homeowners associations and condominium owners associations. And I'm concerned about the unintended results or consequences of legislation. I've been involved in a lot of litigation over the years. One example of a case that I dealt with recently on behalf of an association came about as a result of the xeriscaping amendment to the law. There was a xeriscaping amendment to the property code that allowed an owner in a property owners association to install xeriscaping in their yard, and that was legislation that went into effect without any explanation as to what xeriscaping was. We dealt with an owner who wanted to put rocks all over their yard, and that's what they did, and we ended up in litigation, and we tried to move forward as quickly as possible. This owner actually had 3 different lawyers who represented him in that litigation and had an interlocutory appeal, and it was a bad situation for the association. It was bad for the owner as well. But that was an example of legislation where it had some good intent behind it, but really without understanding how the process would work as far as enforcing that rule. Unfortunately, it's just not gone over well with regard to my association clients and them trying to, regulate yards and adhere to the restrictive covenants. In this case, my concerns in particular are that we have a scheme that allows for, already under the property code, a transition of 1/3 of the board after 10 years if there's not a maximum number of lots. There are annual meeting requirements for all nonprofit associations in the state of Texas. All board meetings have to be open to the public, or at least members of the association. Even though there are carve-outs for the developer period, there's a laundry list of items in the property code that have to be the subject of an open board meeting, even during the development or declarant control period, if the board is to take certain action. Board members owe a duty to act in the best interest of the association, whether they're declarant appointed board members or whether they're elected by the owners. They're also required to post their agenda in advance of the meeting and provide notice to the owners based on the Texas Biz Org Code, Chapter 22, also the Texas Property Code. There's a petition process by which owners can require or force the board of directors to call for an annual meeting if they refuse to hold the annual meeting. Members can typically petition for a special meeting of the members, but the long and short of it is there are a number of provisions that are effective now, at least as far as the associations that I represent, to give us relief if there's an issue where we have to petition the court to force a board or to force the association to take some action.
So let me turn your attention to this bill. On the substitute, with regard to the provisions that call for transparency, maintenance of a website, producing information on the website. What's your position on that?
I'm not concerned about transparency. Transparency, owners are entitled to the information, they have to submit a request, but they're entitled to get basically any records of the association need to be made available to them within 10 business days of receipt of that request. And the fees that are to be charged are based on the Texas Administrative Code's provisions that pertain to open records requests, so they're fairly nominal. In most cases, I'm dealing with responding on behalf of an owner-controlled association, and we're struggling to gather up a lot of information. We typically have to pay a manager to get that information.
And on this substitute, together, these documents will be published and maintained on a website?
I wasn't prepared to address that, but I can speak to the issue.
Well, I would appreciate it because that's what the substitute is mostly about. So I would hope that you can address that.
Sure. So typically, well, right now there is the website requirement as far as maintenance of governing documents, and the governing documents are documents that are filed of record. They have to be recorded because under the property code you can't enforce a rule as an association unless it's been recorded. And so the same documents that are required to be posted now are also found, they can be accessed through most of the county records websites. This expands that information, and so, or expands the amount of information that needs to be made available online. In my experience, providing information online, a lot of associations that I represent already provide that information online, or it's available on request, or it would be produced at a meeting. So by making that available online, it is adding some administrative burden that would result in additional management fees, to have to process. And
So
upload.
I'm clear, all the members of the association could make a manual request for these documents and have a right of access to them, provided that they meet whatever administrative requirements that are in statute. What this substitute is saying, rather than do that, you make them accessible for one and for all on a website, which I think reduces your workload and your administrative burden. And so I'm just, for the purposes of the author of the substitute, I want to narrow this down for him. Are you all okay with that provision of the substitute that calls for making these documents, producing them online, and making them available for those, in addition to the ones that are required to? But on page 3, line 9, regarding board meeting and minutes of the board meetings, they'll also be placed online within 5 days after the conclusion of the meeting.
We have a position with regard to the transition from declarant control.
Well, let's get back to my question. My question is about these documents.
Oh, right, no,
and
no.
making them publicly available online. And you said you don't have a problem with the transparency. I'm trying to figure out what pieces of this bill that we might be able to work towards in terms of finding a solution. And are you okay with that?
And I'm sorry that I'm not being very clear. I don't have a position on that,
Okay.
but personally, I mean, I'm okay with that. I'm okay with
Well, I don't need your
transparency.
personal. I mean, you're here on behalf of the Texas Association of Builders.
That's correct.
That's what we're going to hold your testimony accountable to the Texas Association of Builders. So your personal opinion really doesn't have a lot of value for me. My question is this: I mean, this seems to be a big transparency piece in this legislation Chairman King is working on. It's my job to sort of flesh out what the issues are so that I could advise Chairman King on how he might be able to repackage his legislation to garner the support of this committee. And a big component of it deals with transparency and making documents available online, as well as board meeting minutes. And I need to know if that is something that you oppose, or are you for?
Oh, I don't have a position. We're neither opposed nor for it. I mean, it would have the same impact on a developer-controlled community as it would have an owner-controlled community.
So you're opposed to the bill, but you're not opposed to that?
Correct.
Okay, thank you.
Mm-hmm.
And then there's another piece with regard to the composition of the board going from 1/3 property owners to a majority. I'd like to know your specific position on that.
Yes, we're opposed to that.
Okay, and tell me why.
You're talking about the transition of the majority within 5 years if there's not a maximum number of lots?
I'm talking about section 5, line 21.
Correct. It's a one-size-fits-all approach that might work well for a smaller community, but wouldn't work well for a large community. In most cases these days, the larger subdivisions are phased in over time, and so it's just too difficult, too cumbersome, and too expensive to have the development plan submitted to the governmental entity and have everything, have all of the property subdivided before you break ground or transfer the first lot. And so it just wouldn't be workable for the vast majority of modern developments that are large in scale and scope.
Do you have any suggestions on how we might be able to tailor some language so it's not necessarily a mallet that would apply to all circumstances, but perhaps some sort of test or criteria that must be met before you can transition from a board of 1/3 property owners to a board that is a majority property owner board?
I mean, the current statutory scheme, I think, works well.
Well, the current scheme is 1/3, and I think the
Correct.
proposals for a majority, your response to that is that it's not workable in all scenarios, which I'm willing to spot you, but in return, I need you to give me some guidance on how we might be able to apply it, in what instances will it make a good idea to have those associations transition over to majority property owner board.
It's difficult to come up with just a single approach. and to apply, in blanket fashion to all of the communities, just based on the variations.
I would agree with you, except for the fact that we have a blanket provision now.
Correct.
And so if it works in one conception at 1/3, and there seems to be a discussion about moving that to another blanket provision, I'd like to maybe engage your thoughts, and if it's okay, you can give me the answer offline if you want some time to think about it. You don't have to have an answer right now.
Sure. Well, the comment I would make right now is, I guess one of the issues with the proposed legislation also is if someone were to come up with an inflated number, simply to make sure that they have the opportunity to hang on to control for as long as possible. I mean, I think that's a shortcoming of the proposed legislation as well. So perhaps if you had some percentage maybe tied to the majority transition, so the majority of lots or 75% of lots that that can feasibly be developed to where it is actually tied to some type of development standard, and usually they'll have some idea based on the density requirements. And I think in this case, and I want to mention too, we're not against Laboda or the owners that you've heard from or the owner that spoke this evening. We're certainly sympathetic, and so we're not defending that developer.
Sure.
But I think that you have to take into consideration just the feasibility based on the fact that someone would be able to put an inflated number based on the proposed legislation.
Okay. Well, I appreciate it. I don't think you've testified in this committee before, and for other witnesses that will follow, it's sort of the intent of this committee to make sure that stakeholders meaningfully engage with the author of a bill and work, in an expeditious manner to sort of narrow the issues and see if we can come up with some language. And I often will ask the author of the bill to keep the committee apprised as to those conversations to make sure that they're actually happening. And if they're happening in good faith. And so if you would just do us the honor of getting the opportunity to visit with Chairman King on these issues and see if we can find some middle ground on it.
We've offered to do that. We have met with him, and we've also met with the Laboda owners this afternoon to talk through some of those issues and to see what sort of support we can offer them. Okay. And so we'll continue those discussions. I've provided my information, and we intend to have some follow-up discussions just to see how we can address their situation as well.
Appreciate that, members. Do we have any questions? Chairwoman Collier has a question.
Yes.
So I just want to get clarification on how the process works now. So if a developer has the control of they spend money to, plot out the land and all that stuff, and they create the development of the property. Mm-hmm. So at what point does it transition over into allowing the homeowners to have a part in the process of being, stakeholders or board members? Is there something in law right now that says after 5 years, because I heard you say something about 5 years, and without, if a certain number of lots aren't there, is that when that trigger of the 1/3 is right now?
That's right.
So right now, if they don't have certain number of lots.
Well, not 5 years.
Oh.
A maximum number of lots, 75%, they're required to transition at least 1/3 of the seats. And by transition, we mean they have to call a special meeting of the owners, so the owners get to select or get to elect a director to serve on the board. If there is not a maximum number of lots that may be developed, then the default rule is after 10 years after the date that the declaration is originally filed, they have to call that special meeting to transition at least 1/3 of the board.
Okay, so that's 10 years.
Correct.
Okay, and so I think that what Chairman is asking is there a certain way for us to get that number? I mean, what if you did lower that number? And then on the other side, my mind is thinking, well, if you're developing the property, you want to make sure that it's in a certain, you want to make sure that it stays a certain way, so that way you can go market it to potential investors, right?
Correct.
And so that's what your concern is. It's like we want to make sure, and that's why developers want to have the control, I'm sure, is that we're still marketing this. We're still doing phase 2 and 3, so they want to have control over it. But at the point where you have 75%, whether that's 2 years or 5 years, would you be amenable to say, okay, whenever you get 75%, wouldn't that be the trigger to make sure that that's the majority?
Right. And the reason why I was struggling a minute ago and coming up with just some alternative language to present or to consider is because the way that the bill has been drafted, you have essentially a default clause that says that if you don't have a maximum number of lots, there will be this automatic transition after 5 years. And so if you have the maximum number of lots in there, then it goes back to the 75% conveyance of sort of like the way the the way that the statute is set
Well,
up
to me,
now.
if the developer hasn't done anything in 5 years, it seems like they've given up, and the homeowner should take over and take ownership of their property and be the ones that be proud of their property. So if they want to do that, I don't see what the issue is. In 5 years, if there's nothing done to sell, I'm just trying to figure out, wouldn't they have a role of pushing the process forward?
Right, but my point is that right now, if someone were to put a maximum number of lots in there, even if it's an inflated number, it would still be a way to avoid, the transition after 5 years, because that's a default rule that only applies if they don't have the maximum number of lots that can be developed. And so what I was struggling with a minute ago was just on the fly trying to maybe think of a suggestion to deal with what is really feasible. So, for example, if I have a 10-acre piece of property and I can't possibly put 200 lots on that because I know that the local regulations only allow for, density of 4 lots per acre or something like that, I think it would be realistic to impose some sort of requirement that's also tied to the feasibility with regard to, what you can actually do with that piece of property. So trying to balance just the conceptual nature of modern development process where you're saying, okay, well, we need some flexibility to perhaps put a condo on this tract over here and then maybe have larger lots on this one piece of land. And so trying to come up with some type of an estimate on day one as far as how many lots you might develop, and so at what point in time you'll transition, trying to find some way that focuses on feasibility. Otherwise, it just gives someone the opportunity to put, again, a vastly inflated number in there simply to end up in the same situation where you have owners who just don't have the opportunity to participate in their own governance scheme for many, many years because of the fact that the owner, the original developer, has no intention of developing the property further, probably has just a small piece of land that they can't possibly do anything with, and yet they're still in control of the board. So there are a number of ancillary issues. I mean, in this case...
But in that case, wouldn't you think that the homeowner should have the right to take over then?
Yes.
Okay.
But I'm saying that the legislation right now, the way it's drafted, is not, it would not effectively address that situation if they were to put in an inflated number of lots.
If they said, we want 200 lots and it really can only accommodate 50.
Correct. Or, yeah, if they just have 1 acre left, but they still have this number of, 200 lots that may be developed.
Well, I can certainly understand the goal of trying to complete the development, and you want it to be marketable, the developer does, because they've made a large investment in it. But at some point, it seems that the right thing to do is to turn it over to the homeowners who also have made their investment, and if they're the majority there, 75%, at that point, it just seems like that could be the trigger. But I don't think that you're saying completely no. And I think what the chairman is trying to say is where can you come together? And I think that if you keep talking about it and keep thinking, you'll get there.
Correct, and I agree with your point completely. It's just the struggle of coming up with some type of formula that would generally apply and be fair for everyone without creating an opportunity for someone to simply avoid that rule by just plugging in a much higher number than they can actually ever accomplish in reality based on the zoning or planning requirements.
Thank you, Chair Collier. Chair recognizes Representative Moody's being present. Vice Chairman Darby has some questions for you.
Yeah. Laboda, I just pulled up the pleadings of the lawsuit filed in 17, and I've read some egregious actions with regard to homeowner associations. But this probably takes the cake. What are we to do? We have some folks here that are trapped. They're trapped in a situation where you've got developers who are acting in their own self-interest, it appears to me, and not in the self-interest of the property owners. And I understand your concern about making broad policy decisions in statute that may overreach in some cases and some not. But we're going to have to strengthen the ability of homeowners when they are being abused, as I suspect these folks that live in this subdivision are, if even 10% of the pleadings are truthful. What are your suggestions instead of saying what not, how are we to sort this out?
A great example of, I think, some of the problems that you can have with legislation. So in Laboda, those documents refer to a master plan that was never recorded, but the master plan actually refers to, I think, 2,400 lots that can be developed. Is that the maximum number of lots? Is that the number that would be plugged in such that they're able to take advantage of that other clause? Again, I think it goes back to feasibility. If you look at the map and look at what they've done, I think they've conveyed most of the usable land, and the only piece of land that they have left as part of that original master plan is what they had initially reserved for the golf course because of just the elevation changes and not being feasible. So I think if you go back to just the feasibility issue and look at realistically what they could have done and hold them to the maximum number of lots that they really could have developed, then I think they're, well beyond that threshold transition. At a minimum, in 1995 is when their original declaration was filed, so they should have transitioned at least 1/3 of the directors in 2005. And so there's no reason they would be able to proceed without holding an annual meeting. They should have had an annual meeting even before the first lot was conveyed if they had the nonprofit association up and running at this time. I think a lot of the allegations in that case pertain to the developer's family members serving on that board who are also entering into contracts with their development entities or, shell companies that they own or control. And that, I don't know more about
broadband
the
or
case,
maintenance or any other number of ancillary missions that the homeowners are having to pay for to developers' family members.
Right, and so there's a Texas Business Organizations Code provision, Chapter 22, that restricts an interested director transaction and sets a pretty high threshold as far as the type of deliberations, the voting requirements for something like that. And so it seems to me that, at least based on the pleadings, I've seen allegations about a number of things that I just frankly don't think are permitted under Texas law and are dealt with in some remedial fashion based on the statutes that are in effect now.
Well, our job is to try to make some sense out of this and try to not be overreaching with regard to our policy, but to address legitimate concerns. And there appears to be a legitimate concern with regard to the type of practices that this developer is perpetrating on the homeowners that live there. So we welcome your continued. Now you're here on behalf of the home builders, right?
That's correct, and we don't condone that type of development behavior or activity. We just want to make sure that the climate is still good in Texas to attract, the investment dollars and developers who want to come here and build those large subdivisions in a responsible fashion.
And following the chairman's comments, you are meeting with the bill author to address the concerns that this bill is trying to fix.
That's correct, and we've communicated with the lawyer representing the owner group. We've communicated with the owner group, and we've committed to continue to do that to see what we can do and offer our assistance.
Okay, thank you, Mr. Chairman.
Members, do we have any other questions? Alex, thank you for your testimony. You're one of the few that actually registered to testify, and so it was important for us we had to throw all the questions at you. You're the only one that had the courage to come up and testify against the bill in person, so we appreciate that. But we certainly are looking forward to getting an update from Chairman King as to these conversations. We'd like to be in a position to learn this issue a little bit better and perhaps be in a position to help. So
sure, and I don't know, you'll have to forgive me. I wasn't very familiar with the process, but I'd be happy to come back up and visit with folks one-on-one if they have any questions about my experience in dealing with some of these provisions and how they play out in litigation or representing associations, because I do have concerns about some other areas.
I think in the short term it'd be great for you to get with Chairman King, and then we'll members of the committee are pretty good about getting the answers to their questions, so they may just call you.
Sure, I appreciate it. Thank you for your time.
Thank you very much. Chair now calls on